Thank you.
SJC-11237, Commonwealth versus Humphries.
Yes, counsel, good morning.
Good morning, Your Honors. My name is Tom Frothingham. I represent Delaney Humphries, the defendant appellant. And the first issue I'd like to talk about, and this is the due process argument, and that Mr. Humphries was denied due process under the 14th Amendment because in this case, which was prosecuted solely on a joint venture theory, he would have been required to prove or bear the burden of production of bringing forth evidence of the lawfulness of the possession of the firearm by the other party involved, and an alleged joint venture who remained untried in this matter.
So you would say, if I putting your two arguments together, that at least in a case such as this one, that the Commonwealth has an obligation to produce evidence that whatever that bureau was that you mentioned, that, I mean, some evidence that in the statewide depository, there's no suggestion that the brother had a license.
Yes, Your Honor. First of all, it wasn't his. I just want to make a point. It wasn't his brother. It was he said referred to him as a blood relative. The judge made a mistake in one of the
I'm
rulings.
sorry.
That's
okay.
I mean, just in case that makes a difference.
No, it didn't. But anyway, yeah. But the co-defendant.
Right. My argument is that there needs to be a rational connection made between possession of a firearm and unlawful possession of the firearm. And in Massachusetts, I think that the Commonwealth should at least be required to present, and it doesn't necessarily have to be evidence that there is no license in existence, but that would be, I think, at the first step is to check with the Department of Criminal Justice Information.
And all I'm trying to do is sort of, you make that argument somewhat more generally, but at least as to this kind of case, you would say you have to do that. And then would it be the defendant's obligation to put in evidence that he didn't have one, that he did have one?
No, see, in general, that was my argument, I guess, was that in any case in Massachusetts,
I appreciate that.
The Commonwealth should be required to produce evidence of unlawful possession. Then once there is a rational connection made between possession of a firearm and unlawful possession of a firearm, then you get down to the next test, which would be the comparative convenience test. And to apply that test, the Commonwealth would have to show that the defendant is in an equally or better position than the Commonwealth to show that the possession is lawful, which in this case, I think the Commonwealth loses on a comparative convenience test, just as the decision in the habeas ruling in Gonzalez v. Dickout. So really, I think my argument is that the rational connection test is just the first step, and then once that's made, then you get to the second step. So in this case, I would argue the Commonwealth doesn't even get to the comparative convenience test. But if they did, I would argue that they would still lose on that ground.
But this was an assault with intent to murder and assault by means of a dangerous weapon and then possession of the firearm without a license, essentially.
Yes, Your Honor.
The defense in the case was what? Some other person did this? I wasn't. Your client didn't do the shooting. This other person did the shooting.
Right.
A blood relative.
Right. I think.
So what was the defense in the trial?
I'm sorry. I'm just sort of I'm just not thinking about the trial, and the as far as the lawful possession goes, I think
It was ID, wasn't it?
No, I thought wasn't the claim that I had no clue that this crazy guy was going to do this?
I think there was some argument along that lines, although and that came from the interview by the police with the defendant. The defendant didn't testify, but he did say in his interview with the police that he did not know that the other man was armed with a firearm. So I think maybe
so that this was not part of a joint venture. If this person did it your client had no involvement in setting it up or
I think it was a
arranging?
knowledge of the firearm that's what the defendant in his interview with the police said. He didn't know that there was a firearm, didn't know the joint venture had a firearm, and that clearly the jury didn't believe that. And
Well, I guess my question is, was there, at trial, was this issue raised at all? The issue of what the Commonwealth had to establish in order to establish illegal possession of the firearm?
You know, Your Honor, no, I don't think it was raised, and despite that, I would still argue that this should be reviewed under a harmless error standard, because at the time this case was tried, this followed after the Commonwealth versus Gonzalez case that was heard in the appeals court. And the Commonwealth versus Gonzalez, which was ultimately went up on the habeas petition to the district court, was affirmed by the appeals court, and further appellate review was denied before this case happened. And the facts in that case are very similar to this case. And then after Mr. Humphries was convicted, the habeas petition was ruled on, and it was said that the Commonwealth, that the defendant cannot be burdened to prove in a joint venture prosecution or bear the burden of production that the other party has a license. And I think that's analogous to the sort of Verdi, Melendez-Diaz-Vasquez decision, where in Verdi, this court said that certificates don't bear confrontation rights. Vasquez was tried,
Right.
I think. So it's a similar thing. So even though it wasn't objected to at trial, I would argue that the burden should still be a harmless error.
But the obligation under Rule 14b-3 to provide notice based upon a license is not new, and I gather there was no notice given here.
Well, I would argue that it's this. No, there wasn't. It wasn't. The defendant did not come forth and say, I have an affirmative defense that there is a license or other lawful authority in this case. But I would argue that would put the same burden on the defendant as was found to be impermissible in the Gonzalez v. Dickow ruling. It would require the defendant to set forth some sort of knowledge of an affirmative defense of which he can't be fairly required under the definition of an affirmative defense, which is that it's a justification that is of knowledge peculiarly in the possession of the defendant. So I don't think you can say that Mr. Humphries should have knowledge about Mr. Hawley's license status or some other exemption that he can put forth at the beginning of trial and give notice that he's going to mount an affirmative defense.
But there's a difference between giving notice versus an obligation or a burden of production. Why shouldn't he be required where he's going to make this defense to provide notice as required by the rule?
Well, I would argue that, the burden of production is you have to come forth with some evidence. What is he supposed to say? I'm going to mount an affirmative defense, there's a license, and then with no evidence of that? Because it should,
No, he's simply going to say that my defense is that there was no license, and therefore the Commonwealth is on notice that it has to prove that. I mean, isn't that what Rule 14 is supposed to do, is to give notice
That there was a license.
that there may be a license, to at least essentially say, you now must prove this because I'm putting you on notice that I am going to argue this as a defense, and therefore you are given notice. It's comparable to alibi. I'm going to give notice that there's going to be evidence of an alibi, and therefore I plan, you had better, you're on notice that you should rebut it.
Well, I understand that, Your Honor, but I would still say that as the definition of an affirmative defense, as comes from recited in the Gauss case, relying on previous cases, was that an affirmative defense is a matter of justification peculiarly within the knowledge of the defendant. So this is not, in that sense, and I don't think you probably, I don't know if you saw the recent ruling over the weekend or just last week in Powell, the federal district court in Powell said that the decisions in the Massachusetts in this court are incorrect regarding the definition of a license as an affirmative defense, that a license is not an affirmative defense, that it's an element of the crime. So that just adds more confusion to this, but I would say that a defendant should not be required to come forth with notice of an affirmative defense when the information that would be included in the affirmative defense does not fairly fit within the definition of an affirmative defense because it's not a matter of something that he should have knowledge of. So I would say that right there is, I think you run into the same problem. It's almost like you're supposed to present an alibi for somebody else. And it's just, I don't think that's fair. I think that runs into the same due process concerns as requiring a defendant to show the license status of another party. But I don't know if you saw the case in the habeas ruling that came out. I think it was either, I don't know, it might have been March 1st or February 28th, but it was a ruling by Judge Young and Powell v. Tompkins, and it specifically stated that based on that the federal district court considers possession or lack of a license to be an element of the crime of unlawful possession of a firearm.
Well, that may be, and that may be his view. We've said otherwise
I understand
100
that.
times.
I understand that, Your Honor, but I think that it is, the case law, for instance, I think since the Second Amendment has been applied to the states, the analysis should be different. And I think that all the cases refer back to Jones, which first characterized the possession of a license as an affirmative defense. And Jones, the statement in Jones that the prohibition is general and the license exceptional, which is, I think, the rationale underlying the definition of a license as an affirmative defense, comes from a case, a 1920s case, an alcoholic beverage sales case, which took place between the ratification and repeal of the 18th Amendment. So what you've got now is you've got that type of reasoning being applied to Second Amendment cases. The 18th Amendment specifically prohibited alcohol sales, so that's clearly the
But you don't have to take on Jones and Gauss because you've got you've got the dick out situation.
Well, it's true. This is one step removed. But I'm saying that in order to get to the rational or the comparative convenience test in this case, I think you have to go through the rational connection test. And I think that is more applied to presumptions than affirmative defenses. I think, but the definition of an affirmative defense in this case is pretty much the same as it requires a presumption. And so it's very confusing, and I don't know if you can say that, if you say that it's not a presumption, it's an affirmative defense, are we going to apply the same 14th Amendment analysis to that and say, well, it presumes the defendant has knowledge of something that he doesn't, so therefore it's an unfair affirmative defense as opposed to an unfair presumption? I mean, that's where it gets confusing, because you say it's an affirmative defense. If it were a presumption, you would say it's not a rational presumption, and with the presumptions, as in Morrison and Tott, then it's not a rational presumption, or it doesn't meet the comparative convenience test. So are you going to, do we analyze affirmative defenses the same way as we're analyzing presumptions? And if so, then you're right. I would argue that you get down to the last test, the comparative convenience test, and it's procedurally unfair to require Mr. Humphries to show the license status of Mr. Hawley.
So if I can go back to your argument that there is no burden upon a defendant to provide notice of defense of a license, which would mean then that the Commonwealth would have to prove it in every case, correct?
Yes, if I don't say, the Commonwealth would have to prove a rational connection, I would argue, between possession and unlawful. So I don't necessarily think.
I'm sorry. So the Commonwealth would not have to prove that that this fellow had no license, that the cousin had no license in your world?
No. The Commonwealth would have to adduce evidence sufficient to shift the burden to the defense to come forward under an affirmative defense. They would have to show something connecting the possession with unlawful possession. And if so, okay, say for instance there's, they come forward and say, Mr. Hawley does not have a license. Okay, that's enough to shift the burden to, I think we would say in a normal case, not in the case, say it's just Mr. Hawley. Say, Mr. Hawley didn't have a license. He's being charged without having a license. Commonwealth comes forth with evidence he doesn't have a license. That would then shift the burden to him if he has some other exemption. An exemption under the statute in Massachusetts, there are many exemptions for possession of a firearm. For instance, if you return to the state after being gone for 6 months, you don't need a license for 60 days. I think there's an exemption like that. If Mr. Hawley had just come back, that would be something peculiarly, knowledge that he would have. So then he could come forth and say,
He being Holly or he being Humphries?
no, I'm talking about Hawley. This is removed one step from that, Your Honor. I'm sorry if I'm confusing it, but I think there's two. In the case of an individual who has a firearm, it's different than in the case of a joint venture. But I'm saying in the case of an individual with a firearm, the Commonwealth should at least have to come forth and say, we checked the Firearms Records Bureau, there's no license for this individual. Then if that individual has some other exemption which only he would know about, he was out of the state for 6 months, he just returned, didn't have a license, or he just moved here, doesn't have a license, I think then that would be something that is peculiar to that person, that they should be required to come forth.
But why is that, though? If the Commonwealth has at least proved that the defendant knew that this other person had the gun and knew that the gun was being used for an illegal purpose, for the joint venture, why isn't that enough to shift or to require the defendant to at least know that the person who has a gun and they're going to use it for a certain purpose, that the person is licensed?
Well,
the defendant should check on this before he gets involved in a joint venture.
well, that's been stated that he runs the risk. But
No,
that's
and it's not the same thing.
Okay.
He is knowingly, and this is what the Commonwealth presumably has proved, and otherwise it wouldn't get beyond the required finding status. The Commonwealth has put forth enough evidence upon which a jury could reasonably conclude beyond a reasonable doubt that the defendant knew that his venture, joint venture, had possession of a gun, and that they were going to use the gun for a particular illegal purpose. If the Commonwealth has met that level of proof as to those elements, why shouldn't the defendant show that? Why shouldn't the burden fall to him to come forward with some evidence?
Well, Your Honor,
that the guy had a gun lawfully?
If you're going to let the jury decide that, that would be one matter. But in the situation we have, the jury never gets to decide that. They don't get to decide that because a specific crime has been committed, we believe that the commission of that crime is such that that person would not have a license, that a person committing this crime would not have a license. But now, which crimes does that apply to? I think you're running into a problem. First, that doesn't go to the jury. The judge decided. In this case, the judge decided it. It didn't go to the jury. It would be a completely different case if the Commonwealth were to present its evidence and the judge were to instruct the jury that they may make a permissive inference that anyone committing this type of crime obviously doesn't have a license. That's a different case. I think in this case, the evidence of joint venture it never went to the jury. I think so. It was more of a mandatory presumption imposed on the jury. It was taken away from the jury. And I
Mr.
think,
Frothingham, I'm sorry I have to interrupt. Your time is up.
okay, thank you, Your Honor. I appreciate that. Thank you for taking this case.
May it please the Court. Good morning, Justices of the Supreme Judicial Court. My name is Stephen Carley, Assistant District Attorney from Worcester, representing the Commonwealth.
Mr. Carley.
Yes.
Maybe I didn't understand one of your arguments, but are you suggesting that if the co-defendant here, Mr. Hawley, was that his name?
That's correct.
Had a license for this gun, to carry this gun on the streets, that the defendant here would still be guilty of unlicensed possession?
That's correct, and only because it was a joint possession.
But
What if he had a license to carry?
Then if he had a license to carry, Mr. Humphries had a license to carry, and Mr. Hawley had a license to carry, then there would be there'd be no unlawful possession.
you get him going and coming. I mean, you're charging him with joint venture. You admit he doesn't have the gun. The other guy is the shooter, and you say he's got to have a license for a gun he doesn't have?
Yes, because they possessed it jointly. If this is not an individual who's unrelated to the events of this case. He's found guilty. He's not only charged, he's found guilty by a jury beyond a reasonable doubt of having jointly possessed that gun.
Is that right? No, it wasn't joint
He
possession.
wasn't.
The jury wasn't
He
given an
wasn't.
instruction about joint possession.
Constructive possession.
No, they were given an instruction about
He was-
constructive
he was-
possession.
he
That's
was-
correct.
Right.
They were
So
given
this-
an instruction that under Zanetti, under our law of aiding and abetting, that he possessed that gun just the same as what in the pre-Zanetti language would be the principal, just in the same way that the principal possessed the gun.
But isn't there a difference between joint venture and joint possession?
Yes, there is. A constructive possession theory is not the same as joint venture. It doesn't automatically, one does not automatically include the other. You could have both. You could go on a constructive possession
So
theory.
is it your view that if I basically say, here's $500, you go buy a gun, that a gun which I never see and never touch, never even, that I'm guilty of jointly possessing that gun with you?
Yes.
Or
I mean, I'm not sure exactly all the elements of your hypothetical, but I don't think in principle that there's any problem with that. You have aided my unlawful possession in the way that, assuming we meet all of the elements of joint venture and unlawful possession, you've aided me in that regard, and you've, therefore, under our law, you are as guilty of the principal offense as I am.
Well, if I haven't supplied the gun to you, how have I aided you? What's the evidence of aiding in the commission of that crime?
Well, the evidence in the hypothetical or in
that hypothetical.
In that hypothetical would be the provision of money that allows me to go and purchase that gun. I wouldn't, presumably, I wouldn't have the ability to purchase that gun if not for Justice Gant's assistance in that regard.
But if I'm charged with joint venture of possession of a firearm, and it is all hanging on my co-defendant, and he's licensed, I don't know why I have committed a crime. And it's never touched my hand.
Because the
Never.
licensing scheme only protects or only authorizes one individual to
Kafkaesque
possess.
world you live in, Mr. Carley.
Pardon me?
This is a Kafkaesque world you live in.
Well, Your Honor, then individuals shouldn't be sharing the possession of a gun, which the jury found in this case. I wouldn't
The
suggest.
joint venture theory provides that someone who's involved in a joint venture is guilty of the crimes committed by others in the course of that joint venture. The crime committed by the other here is Mr. Hawley's unlawful possession of a firearm. But if it was lawful, then there was no crime committed by one of the joint venturers.
I agree. No, I understand the theoretical point that the court is trying to make. And I understand that. But I think in this case, the jury has already found that Mr. Humphries is guilty, not just charged, but guilty of possession of that gun. He's been found guilty on a joint venture theory in which our case law says he's as guilty as the principal under the pre-Zanetti language. So he has possessed that gun. That's if another set of facts presented themselves where, a motion to dismiss, for example, where a jury hadn't already decided that, and the facts were slightly different, perhaps.
The jury has not decided that he has physically possessed this gun. They've decided that he's part of a joint venture in which the person who had the gun was not licensed to have it, and therefore the other joint ventures are guilty of that.
That's correct.
All right, but that's different. But anyway, let's not distract you. What about the other arguments in here? We don't have to decide that question here, I don't think.
Well, I suggest that question is preliminary because if there's no
Let's
if
assume
there's no license,
let's assume we come out the other way.
I understand. I'd suggest that the issue raised here is not one that the jury could have decided. My brother says the jury wasn't ever given a chance to decide this question about where, who had the license or whether a license existed, whether a license authorized the possession at issue here. The reason it wasn't is because there was no notice and no evidence produced in support of the affirmative defense. And as Justice Gantz points out, the comment to Rule 14b-3 says that to raise this affirmative defense, you must give notice. And the comment says that this is all that rule requires. That's separate from the rule of our Commonwealth that we've decided that some evidence must be produced in order to assert it at trial.
Okay, so he gives notice. He gives notice. Well, how can he give notice that Mr. Hawley is licensed when he doesn't have any idea whether Mr. Hawley is licensed or not?
Well, one, I don't grant the premise. He may have an idea, but we don't know because he didn't raise it. So we can't tell what that record is.
But let's just
more
assume
importantly,
hypothetically that he doesn't.
right. More importantly, he must only give notice of his intent under 14b3 to rely on the affirmative defense. That doesn't, he just needs to file something with the court and with the Commonwealth to put them on notice in that regard. It doesn't require the production of evidence that is alleged to be unavailable to him. So in this regard, I'd suggest that especially Mr. Humphries this affirmative defense is not available to him. Maybe to some other defendant it might be. I'd also suggest that that gets exactly to the heart of the issue of this supposed comparative convenience test and whether a defendant has the ability to produce some evidence as the case law requires. We don't know whether Mr. Humphries could produce some evidence because, again, he didn't raise it.
So,
It's possible he might produce
but as a
that
practical
evidence.
matter, how does this play out? A defendant doesn't know, as a matter of fact, but he does, as you say, he complies with the rule and gives notice.
Yes.
I mean, what does he do? Can he get up there and say, can the defendant get up and testify? Look, I didn't know that this guy had a gun, but I also don't even know that he didn't have a license. Is that enough to trigger the issue?
I'd suggest that if, assuming proper pretrial notice of that was given, then that would at least that's some evidence. And this is an interesting question. In reviewing the cases, I don't see a definition or any guidance under 278 Section 7 of what some evidence means. Usually, it's the license itself. That's easy.
Well,
what other, if any other evidence is competent in that regard, the cases don't say.
Well,
so that might be an issue for this court to
If a
decide.
defendant testified, as I've suggested he might,
Yes.
and the judge in his instructions to the jury, or the judge looked to the Commonwealth and said, okay, I think this is enough. You now have to prove that the guy with the gun didn't have a license.
That's correct. Because if it's been properly raised, as you suggest, then yes, the burden
Would you agree with
conceivably
it?
could shift, because if he can show, what I'd suggest is if this court is inclined to fashion an exception for these kinds of cases, then the defendant must at least exhaust his options for producing whatever he can produce. Because the reason the affirmative defense exists is because there's no easy way for the Commonwealth to prove its case about this element, which is not, again, an element of the offense, as Justice Cordy points out. But the reason we can't produce it is because we'd have to check with every police department, and this court has already
What about
decided
this
that.
central?
That's correct, Your Honor, and I've investigated that somewhat. There's no evidence on this record that the comparative convenience falls better for the Commonwealth. But
Is it in fact the case that there is a central depository that provides some evidence as to whether, that is where, I'm not saying that they do, but
Right.
that is where every licensing authority is supposed to notify that they have actually given a license to X, Y, or Z?
I anticipated this question, and so I attempted to find out exactly what's referred to, I think, in the parlance with the law enforcement as CJIS, the CJIS system, whether that might serve as a backbone. My understanding is that can be checked, but that it is not necessarily a comprehensive database and isn't an easy method for the Commonwealth to produce evidence comprehensively throughout the Commonwealth. That's my understanding, Your Honor, and again, I'm not relying on the record, just my own background investigation.
Let's assume it's at some point,
Yes.
this whole licensing thing becomes very routinized, and there is a master record kept,
Yes.
electronic transfers, licenses awarded are instantly put into this database. Does that change anything here?
It doesn't change the notice requirement, because the reason the notice requirement exists is, as Justice Gantz suggests, it's like an alibi defense. The defendant has to identify the affirmative defense in which he intends to rely. Otherwise, the Commonwealth would be required of demonstrating the non-existence of every affirmative defense. So if such a system were created, Justice Cordy, then at least, even in that situation, the defendants would still be required to give notice, which this defendant didn't give. So even if we're inclined to write a new rule with that system in mind someday, this defendant still would not have the benefit of it.
Well, unlicensed driving, those charges are brought all the time. How are they proved? Isn't it just a certificate from the Registry of Motor Vehicles?
I believe unlicensed driving.
Ordinary course of the.
I believe there are cases unlicensed driving and lack of insurance have been found not to be affirmative defenses, that they actually constitute essential elements. that the Commonwealth must
And
prove.
I take it it's
That's my understanding.
I take it there's no confrontation clause issue, or maybe there is, because it's established by a record which is kept in the ordinary course of an enterprise. It's not
Right,
created
a
specially.
non-testimonial record. I believe so. That's correct.
Are we ever going to reach that day where that's the story with firearms as well?
In reviewing this case and preparing for this argument, Your Honor, and having this case for a while now, I would love to see that system in place. But that system, as I understand it, does not exist yet, and I can't create it for purposes of this case. Would that be a better system? Perhaps.
But you could show perhaps that that the person who possessed it was a felon and therefore would not be eligible to.
That would be one method of offering some evidence. But in order for it to be raised in the first place, I think the court can't let go of the notice requirement and the defendant's intent to do or requirement to show whatever he can, whether it means he produces an affidavit that doesn't waive his Fifth Amendment rights, or whether he use his right to compulsory process to try to produce whatever evidence he can in order to show what he knows or what he has available to him. Just because defense counsel on appeal now suggests that the comparative convenience test falls in his favor and not on the Commonwealth's, that's not a factual matter that's established. That might be a factual matter that could be established if this issue were raised by, for example, giving notice under 14b3 and then filing a motion saying to the trial court, I can't produce evidence as I'm required to under 278 Section 7. I'm unable to because of my position. I've tried compulsory process. We can't find the individual. I can't find records on this. In this case, now the burden should shift. That might be a fair result, Your Honor, but that didn't happen here. Nowhere near what happened here. Not even notice was given. And I'd suggest that before the comparative convenience test is applied to a hypothetical set of facts, that we apply the standard burden of at least giving notice and producing whatever evidence is available to the defendant. That's been the standard for affirmative defenses since they've existed and been recognized by the Commonwealth.
Do you think if we had a case where this is all happening in an apartment, and so the issue becomes, and they're charged with, Mr. Frothingham's client is charged with joint venture theory of not having an FID card.
Yes.
So you've got the Second Amendment suggesting that in your home you can have this gun, right?
Yes.
So what happens then?
I'm not actually sure how the U.S. Supreme Court will resolve the matter of whether our FID card statute, requirement is one of the reasonable restrictions on a person's right to possess a handgun in their home for purposes of self-defense. I have no idea. I wish I knew how they were going to answer that question. But in any case, that's not presented here, and I don't mean to dodge the question, Justice Botsford. It's all I can say is they may end up saying that our FID card statute is unconstitutional, but they haven't yet, and it's not the facts presented here, and so I can't say that I've briefed it or researched that question. I just asked the court to look at that. I understand the court's recognition of the issue and grappling with these issues, and the comparative convenience factors don't necessarily fall in this way as they did in previous cases where it wasn't pursued under a joint venture theory. But the fact remains, the absence of license is not an element of the crimes charged here. The defendant did not raise the issue, and in fact, the Judge Agnes, in instructions to the jury, specifically told the jury this issue, a firearms identification card or a license, is not at issue in this case, and you're to disregard or put that out of your mind. It's not something for your consideration. Those were instructions that the defendant agreed to at the trial stage and now raises this claim for the first time only on appeal. There's no record to support the comparative convenience test arguments. I'm also happy to address any other issues. I believe there are 2 other issues raised by my brother's brief to this court. I'd be happy to take any questions on those.
All right, thank you very much.
Thank you, Your Honor.